Okay, great. All right, so here we go. I'm really looking forward to the discussion. I think this is a very important discussion and will be of great interest to many. We have this brand new law that was just signed into law. There has not been anything like this in quite some time. So this is very fun and exciting to talk about EFASASHA and what next, what does it mean, what doesn't it mean, and some of the fun legal issues and practical issues. So for that, we have a panel. And good thing you don't have to listen to me this whole time, right? So we're going to be talking with, first of all, we have Abgail Pessen. She has her own dispute resolution firm in New York City. She's an arbitrator for the American Arbitration Association and one of its master mediators. She also mediates privately. Abgail is past chair of the New York State Bar Association Dispute Resolution Section and is very avid in arbitration and mediation. Dana Welch, she is an arbitrator with more than 20 years experience in commercial and employment disputes. She has served as solo chair or panel member on more than 300 arbitrations. She's a fellow and on the executive committee of the College of Commercial Arbitrators and is a fellow of the Chartered Institute of Arbitrators. She's on the American Arbitration Association's complex commercial and employment rosters, as well as on CPR's roster. She is a member of the National Association of Distinguished Neutrals. We also have Professor Imre Szalai. He graduated from Yale and he went to Columbia for his law degree. After graduating, he practiced antitrust law in New York City, and then he practiced in Miami, Florida as well. Since then, he has become a very well-known scholar in arbitration law and is an authority on the Federal Arbitration Act. I know I've had him speak in my classes, and he is absolutely the go-to on many legal issues when it comes to arbitration law. He has been commenting avidly on the law and the recent US Supreme Court cases. At the same time, we have another rock star as well. We have Professor Blankley, Kristen Blankley. She is a professor and an arbitrator and a mediator as well. She graduated from Ohio State University, where I'm a professor for law school, which I always think is fun as well. And she teaches ADR, she teaches advocacy and ethics in mediation, family mediation, facilitation, and legal professions. She has been very involved as well in ethics with the ABA dispute resolution section and is chair of that committee. We have a fantastic group here, people who are in the know, both from the legal end and the practical end. What I really love about this panel is the fact that it is so varied, and I think it will generate a really important and useful discussion, not only on the law, but also the practice, which is absolutely essential in this area. So to start us off, we're going to start off with Professor Blankley, Kristen Blankley. She's going to kind of set the stage on this new law. You know, what does it do? What doesn't it do? So Kristen, if you don't mind kind of starting us off.
Thanks so much, and thanks for having me here. Just as a background to the Federal Arbitration Act, which is enacted in Title IX of the U.S. Code, and Title IX has 4 parts, and so the first part of Title IX. Part 1 was enacted, of course, in 1925, and for many years, and many of us on the call probably thought that it was, I think I wrote in an article once that it was like as immutable as the 10 Commandments, that that political pressure could not amend the FAA. We've only seen minor revisions to Part 1 of Title IX. We saw some revisions in the 1950s, adding some appeal rights from district courts to appellate courts. In the 90s, we saw Parts 2 and 3 added to the FAA. Part 2 is the New York Convention, and Part 3 is the Panama Convention. And then really for the first time since the 1950s, did we see an amendment to the Federal Arbitration Act, and an amendment that really affects the first part, the first part of the FAA, which is what we're all here to talk about. That's not to say that this is the first time that Congress has made some choices regarding disputes that can be arbitrable. And in the last maybe about 10 to 15 years, there have been a few places here and there. For example, there is, for example, in the revolutionary mortgage legislation, we saw a provision that says that no pre-dispute arbitration agreements in mortgages can be enforced. And so we saw kind of a small slice in the world of mortgage law. For a number of years, we saw Congress forbid pre-dispute arbitration agreements in employment agreements for federal defense contractors. So this isn't the first time in the last decade or so that we've seen kind of this little piecemeal type of dealing with arbitration within certain subject matters. But what this is it's the first time that Congress has actually amended the FAA in order to do so. And so to talk about the amendments to the FAA are small, like small in number. And so, and I want to start with what is codified at 9 U.S.C. 402, because 9 U.S.C. 401 is definitions, and I'll talk about the definitions after I talk about what the law does. So under 9 U.S.C. section 402A, what it says is that no pre-dispute arbitration agreement or pre-dispute joint action waiver shall be valid or enforceable with respect to a case which is filed under federal, tribal, or state law and relates to sexual assault and sexual harassment disputes. And so that's what we're really here to unpack. We're going to unpack potentially the difference between cases and claims, what it means to include federal, tribal, or state law. But essentially the essence of this statute is to not enforce agreements to arbitrate that would cover sexual assault or sexual harassment claims. Interestingly, this particular law is not limited to the workplace. It's hard to imagine other situations where it would apply, except perhaps in the area of independent contractors. And so because it doesn't explicitly, it's not limited to employment arrangements, I would imagine an application of this particular law in both employment as well as independent contract relationships, and I guess other types of contractual relationships. Under section 402B, 402B actually talks about arbitrability, and we'll talk more about arbitrability later, but the statute here says that the applicability of this chapter is determined by federal law. So we kind of have a choice of law provision here, and shall be determined by a court rather than an arbitrator, irrespective of whether the party resisting arbitration challenges the agreement as it relates to the individual term or the rest of the contract, and irrespective of whether the agreement purports to delegate such determination to the arbitrator. So what we see here in 402B is we see Congress reacting to the Supreme Court's rulings in cases like Rent-A-Center, where we have these delegation clauses and that whole arbitrability doctrine. And so we see here that in that arbitrability is specifically reserved to the courts and not the arbitrators. Briefly, the definitions, we do have a definition of a pre-dispute joint action waiver. Essentially, that's covering collective and class actions. It's written pretty broadly in order to cover a number of different situations involving multiple plaintiffs, usually in the side of the plaintiff. And then sexual assault is defined by reference to federal criminal law, and sexual harassment is defined by reference to state, local, state, tribal, or federal law. So neither of those provisions, sexual assault or sexual harassment, is defined differently in this particular act, but it is defined by reference to other law with the intent presumably to be consistent with other law. That's what it covers. And so a couple other things that is not covered. And so the most obvious reaction to this law is that it's pretty limited in the scope. It only applies on its face to cases involving sexual assault and sexual harassment. It does not on its face cover any other type of tort or contract claim. So it does not appear to cover civil rights types of claims, including racial discrimination, age discrimination, or other statutory claims. It does not appear to cover other types of tort claims, other types of assault or battery other than those of a sexual nature. And so it is limited to the types of claims that are covered. It also it doesn't because it doesn't mention employment at all. Congress here is not attempting to amend the U.S. Supreme Court's ruling in Circuit City versus Adams. The Circuit City versus Adams case says that the FAA applies to can potentially apply to all employment contracts other than those in the transportation industry. And so while Congress is attempting to cover some types of workplace disputes, it's also not covering, it's not changing the baseline law that we see in Circuit City versus Adams. And then the last piece, and this is the piece that has gotten the most attention from the press, is that this law does not cover anything relating to settlement agreements, confidentiality, non-disparagement clauses, and other mechanisms that would prevent disclosure of the underlying incident, whether that be within the agreement where the arbitration provision might be, or outside of that. And so to the extent that this particular law is intended to increase transparency through court proceedings, it does not alter the current arrangement and the current practices relating to settlement, confidentiality, non-disparagement, and those types of things. So that's my overview, and I'll turn it back to Amy to start asking the questions.
So great. I hope that kind of set the table, right? So we're ready to, kind of build upon that. And I would just note that we here at Arbitrate, we had a panel of experts on NDAs, and we talked about non-disclosure agreements in arbitration and mediation. So for those that are interested, should check out that recording as well. Maybe Colin can provide the link. So moving on to Imre. So Imre, now we've heard what's in it and not in it, right? And we can talk about the language, and we can talk about what the Federal Arbitration Act amendment, because it is really quite astounding that they actually amended the Federal Arbitration Act. But now what, right? I think a lot of us professors are all sort of having a good time with open questions. There's lots of open questions. So Imre, might you dive in and provide us with an overview of what some of these open questions are now that the act has passed?
Sure. Thanks so much for having me. And Kristen, that was just a wonderful explanation of the statute. And I'm glad you mentioned the consumer aspect, because when I see this discussed in the media, it's mainly in the employment context. And there are, just looking back in the past in recent years, there are a few consumer cases that could be covered. I think there's some cases against Rent-A-Center, where one of their delivery people ends up assaulting the customer at their home. And so I think that this amendment will mainly apply in the employment context. And I'm glad you stressed that it's also broad enough and it covers the consumer context as well. And so I do see a lot of problems with the statute and how it's drafted. And I'm curious, I'd really like your thoughts, everyone's thoughts. How serious of a problem do you think that there really is? And maybe these are just crazy hypotheticals that I'll just test my students on, but I want to really find out, how realistic do you think these problems are that I'm about to share? And so first, I'm very, very much in favor of this new amendment, and I strongly support its goals. And I wish actually it went further. Unfortunately, I do think that this new amendment is poorly drafted. I think that the drafters could have done a better job clarifying their intent in the language of the statute. And so there are some uncertainties. I think there's likely to be litigation over how the amendment should operate in practice. And actually, I have a slide that I'd like to share just to help explore these different possible views involving the statute. And so I do see three possible views that could arise. There's three different interpretations that could arise out of this amendment: a strict narrow view, a middle of the road approach, which I'll explain a little bit later, and also a broad expansive view. And I think to consider these different interpretations or these different views, and I think there's some other combinations or permutations of these different views, but to help consider these different views, imagine a hypothetical complaint that involves, say, 4 counts, like a 4-count complaint for sexual harassment, gender discrimination, racial harassment, and perhaps a contract claim or a wage claim. Under a narrow view, I think a court may say that only the sexual harassment claim stays in court, and all other disputes under a broad arbitration clause go to arbitration. And there are some statements from members of Congress suggesting the amendment should be interpreted narrowly. And it's just as a warning, I think that there are statements in legislative history that support all three views, which is a little bit frustrating. I really wish the statute were clarified in its text, but there are some statements from members of Congress suggesting a very narrow view, that only the sexual harassment claim, it stands alone. And actually the House report that went along with this bill, it describes the law as preventing enforcement of an arbitration agreement with respect to a harassment claim. And so it's almost like this particular report, the House report, focused very heavily on the blue language that I highlighted, that an arbitration agreement is simply not valid in connection with a sexual assault claim or sexual harassment claim. But of course, if you look at the statute and what I've highlighted in yellow, the word case, it's obvious there. Just the statute is drafted more broadly to say that the arbitration agreement is not enforceable with respect to the entire case. And so under a broad view, all 4 of these claims would stay in court, and the arbitration agreement is not enforceable at all with respect to the entire case. And there was a member of Congress who gave an example where there's a harassment claim joined with several other workplace claims. And this member of Congress said that all claims will stay in court, and that's just the broad view. And as a clarification, actually, the member of Congress said that all claims would stay in court unless perhaps the harassment claim was dismissed first. Perhaps the harassment claim would be dismissed first on a 12b6 motion, on its own, or a summary judgment motion, just for focusing on that one claim. Or maybe the sexual harassment claim gets settled. But if the sexual harassment claim gets dismissed first or settled first, this member of Congress said that all other claims would be immediately sent to arbitration. But this suggests that at first, as long as there's a pending sexual harassment claim, all other claims get frozen in court as well. Not frozen in court, but they'll be heard in court under a broad, expansive view. And now under the middle view, the amendment covers sexual harassment claims or sexual assault claims, and then any other claims with a close nexus that perhaps arises from the same transaction or a common set of facts. And there are some senators that spoke of this middle view, this nexus view, when debating the bill. And my preferred view, and I think, unfortunately, the legislative history suggests all 3 views, but my preferred view would be the middle view, the nexus view. I think the word case, at least in federal courts, is a loaded term that it's meant to capture, all related claims. My preferred view would be the middle view, that the sexual harassment claim and sexual assault claims, they would stay in court as well as other related claims. And unfortunately, I believe that there will be litigation over which of these 3 views is correct. And Senator Graham said something interesting, and actually he said something that is reminiscent of what was said back in the 1920s. He said that if there's any problems with this amendment, if there's any gamesmanship with these different views, if there's an abuse of this amendment, there's an understanding with bipartisan support that the amendment would be quickly revisited and revised. And actually something similar was said back in the 1920s, that let's pass this immediately. There's such a pressing need for the FAA that if there's any ever problems with the FAA, we'll immediately take care of it in an amendment, but such a pressing need, let's pass it right now, even though it may not be the best drafting back in the 1920s. And so we've gone like decades without any amendments though. But Senator Graham mentioned, or at least recognized, there could be some fights over which view is correct. And think about this, if the court adopts the middle view, which I think is the correct view, it's a reasonable view, there will be additional fights over which claims are related. And I'm thinking of some tough hypotheticals, like what if there's intersexual harassment allegations, like based on both a worker's gender and race? Like, what if a manager in one incident engages in behavior that's both sexual and racial in nature? And just to add more complexity to this, imagine if a court, a particular jurisdiction, adopts the middle view, but the arbitration clause is drafted to incorporate the narrow view or the broad view. That will a court compel arbitration there? Will the arbitration agreement control? And I just don't know. And another problem that will have to be sorted out is if claims are indeed split, like if the court holds on to some claims and other claims are sent to arbitration, I think additional problems will arise, such as, can the court stay the litigation of the sexual harassment claim while the arbitration takes place? And I do see some problems like that. Like, imagine if claims are split between 2-4 like this, and imagine a court stays the lawsuit of the sexual harassment claim because the court takes a narrow view of the amendment and all other related claims get sent to arbitration. You know, courts generally have the power, just inherent power, to stay their own, to manage their own dockets and to stay litigation. But staying the sexual harassment claim is problematic in my mind. And this is not exactly on point, but you know, Section 3 of the FAA allows for a stay of litigation so that arbitration could occur. And if the court decides to stay the harassment claim, it's almost as if the arbitration again is interfering with the hearing of the sexual harassment claim, and that result seems contrary to the spirit of this amendment. You know, arbitration is not supposed to interfere with a quick resolution and or litigation of a sexual harassment claim. And so I'm wondering, will courts stay the court proceeding, the sexual harassment claims, so that arbitration can take place? And if arbitration takes place and if it occurs first on related claims, what will be the preclusive effect of any arbitration findings that finish before litigation? There's already uncertainty regarding how preclusion doctrines operate with arbitration. So if an arbitrator makes a finding that a certain statement was made or a particular contact was made between the worker and a manager, or that a defendant made a particular statement, would those findings bind the federal court or the state court? And that would seem like arbitration again is interfering perhaps with the enforcement of a sexual harassment claim. And so I do see a lot of confusion. And maybe these are just really rare hypotheticals that are rare to arise, unlikely to arise. But I think the most likely problem will involve just how should we interpret this amendment in terms of scope? A broad view, a very narrow view, a very strict view, or perhaps this middle of the road approach, this nexus approach. So I can foresee a lot of litigation involving just the meaning of this amendment.
Yeah, I have to sort of chime in and say, I think, you know, it's not just musings. I don't think these are just odd hypotheticals. When I was in practice, in fact, we had lots of preclusion questions that came up, even in construction arbitration. And I can imagine with split claims, what sort of issues could arise. Absolutely, issue preclusion could be a question, right? And then there's also just the very practical issue about litigation concerning arbitration. If the function of arbitration is to promote efficiency and fairness, you're supposed to, right? If that's what you want in an ideal world, that doesn't seem very efficient if you're going to have this much litigation about arbitration. But it brings us to kind of the practicalities, right? We can kind of have all sorts of fun discussions about hypotheticals and the law and the interesting legal issues. And then the question comes, okay, so what? Who cares? Practitioners on the ground, does it matter? And it does, because these are obviously questions now they're going to have to grapple with and decide what to do about. And we're going to go first to Dana. And Dana, I wanted to get your thoughts on exactly that, right? We have this whole, we set the table, we talked about open issues. What are your thoughts on sort of what now? What do you see in your own practice being applicable issues that could arise?
Well, thank you for having me. And Imre set it up exactly correctly. He said what he said on a theoretical level is exactly what I see happening on a practical level, or will happen on a practical level. Previously, a plaintiff would file an employment claim in court, and the employer would come in with a motion to compel, and boom, it went to arbitration. What's going to occur now is that the plaintiff is going to file in court, and the employer is going to file a motion to compel, but the court is going to be faced with every single question that Imre brought up. And there are going to be conflicts in courts determining whether the whole case stays, whether as Imre described, the narrow view prevails, the middle view prevails, or the broad view prevails. And certainly the plaintiff bar is going to be arguing that the broad view prevails. The defense bar is going to be arguing the narrow view prevails. There's going to be a lot of litigation about this. And just like there was been almost 100 years of litigation about the FAA that has brought us to where we are, I can see these kind of questions going all the way to the Supreme Court. I doubt that Congress is going to get in there and amend this act. I think that it's going to be these questions about what is a case, what is a claim, what does the court retain, what's issue preclusion, which I agree is an extremely unsettled area within arbitration, are all going to be resolved by the Supreme Court. But to say that this is a seismic change in employment law is not an overstatement. The other thing that should not be ignored is that class action waivers are no longer valid in this context. So let's not forget that one. That is a big change for employers who really have been cheering every single time the Supreme Court has said, unless you say that class actions are permissible, there are no class actions. This means that in this context, an employer is going to face class action claims with respect to sexual harassment. So it's a seismic change, which is really going to change the landscape, I think, between the balance between arbitration and mediation, which we'll talk about in a few minutes.
Yeah, and maybe
the other thing that I wanted to mention is that the courts will resolve the question of what's arbitrable. They'll also resolve the question in the statute of did these claims accrue or arise before or after March 3rd, 2022. So all of those claims that previously an arbitrator or all the questions of arbitrability that previously an arbitrator ruled on will now be resolved in court, which I think will make the process more burdensome and longer and more extensive, but that's the result of the statute.
Yeah, lots of good stuff for us to think about. And we'll get back to kind of diving more into this question of mediation. And with that, I'm going to go to Abgail to sort of set that up, because as Jim actually put in the chat, what about mediation? Does that mean that it might be more efficient, easier, more fair, perhaps, to move to mediation in a lot of these cases? I wondered your thoughts on that.
Well, I predict that mediation will be turned to more frequently and earlier as a result of this new law. So we all seem to be assuming that plaintiffs are going to just flock to the courts now instead of arbitration once they have the choice. Not necessarily because it will be faster or cheaper or fairer, but because their lawyers are going to advise them that their case will have a higher settlement value if it's filed in court. I mean, that is what I am told from lawyers on both sides. Now, the management side lawyers know this also. And so I think they will be motivated to suggest mediation early to cut their losses and to prevent unfavorable publicity from a publicly filed lawsuit. I think plaintiffs, this is a practice tip to the plaintiffs bar, they'd be well advised to mediate early too, before filing, to take advantage of that new leverage that they have, which is the threat to the company of some damaging public filings about their supervisor or whoever, and the danger from that of a ripple effect as other female employees at the firm learn about this complaint that's public, and they say, as it were, me too. So once the complaint is filed, though, that leverage is reduced because then the cat is out of the bag. Now, I think that the damage to the plaintiff herself, though, is also underappreciated. The danger from publicly filed pleadings. So we hear so much, and when the law was being debated, we hear about the need to shine a light on harassers and predators, and that's fine. But I'll just tell you, I have never mediated a case where that was of much importance at all to any plaintiff. I mean, that's anecdotal, but that is the case. They are interested in, and fairly so, in monetary compensation for what they've been through. And in fact, their lack of interest in publicizing their dispute is borne out in New York in the context of the NDA, which Kristen talked about before. So New York has had a law since 2019 that a settlement agreement can't keep a lid on the facts about a harassment or an assault unless the victim, the plaintiff or the claimant, consents to keeping that confidential. After a two-step waiting period, it must be in writing. It drags out to 28 days of waiting before you can finalize the settlement. But I will tell you, I have never seen the consent withheld, and I've never seen it raised as a bargaining chip in the mediation. So I just think that it's really the very rare plaintiff, the Gretchen Carlsons of the world, who wants to shout about her abuse from the rooftops. And if I can just go on for another minute or two, Kristen, you know, filing a complaint in court online for everyone to see is very risky for the plaintiff. So, you know, litigious employees are radioactive to future employers. Nobody wants to be walking on eggshells. Is this person, you know, a malcontent? And I'm going to tell you a cautionary tale from an arbitration I had recently, very quickly. It's interesting. The claimant alleged he was fired for a discriminatory reason. And he started his case in court because, like many, he didn't even know he had a mandatory arbitration clause, right? So he filed his complaint and then he was compelled to arbitrate. So the case was arbitrated. And he testified in the hearing that he couldn't find a new job after months of looking, and this was relevant to mitigation, because a newspaper had picked up his original court complaint. And there it was on Google, you know, and whenever a prospective employer Googled his name, there popped up his complaint. And, you know, it's ironic, really, but note that if the case had continued in court, there would have been much more damaging material. This was just his complaint. But then when a case goes on in court, there'll be the summary judgment motion, which is, you know, ubiquitous, and there will be all kinds of damaging material about the plaintiff, because often poor performance is the defense to a termination claim as the non-pretextual reason. So, and in a sex harassment or assault case, this will be even more true. There'll be more salacious material online for all to see. So, you know, I just be careful what you wish for is what I'm saying here. I'm just not sure the rush to court with all its touted benefits is really going to be good for a lot of plaintiffs. And but I do foresee an increase in mediation, because I think both sides will recognize the downside of airing all that dirty laundry in public.
Yeah, if I can just jump in, I think you make really great points, Abgail. And what you highlight is a potential conflict between the plaintiff who wants confidentiality and the lawyer, the plaintiff's lawyer, who wants the biggest settlement. So it's, you know, I agree with you that it's the exceptional plaintiff who wants publicity about these kind of cases.
Well, I had a question for Abgail, and that is, and you are predicting that there might be more pre-filing mediation, and I don't doubt that that might be true. Pre-filing mediation is, of course, really an interesting time to be mediating, and especially in a case like this where, where an employer might have far more information than an employee. And I'm wondering if you think these cases might mediate multiple times. If they don't settle pre-filing, might these cases have multiple rounds of mediation?
Sure, that would be great. Yeah, and I mean, in this kind of a case, I don't know how much discovery is really needed. The plaintiff knows what happened. You know what I mean? It's not like comparative salaries and things like that where you need a lot of data. But sure, yes, the employer will have the advantage at first. But, there can be limited discovery. Exchange is often part of mediation. Good point.
I was wondering about something that Abgail mentioned. What will be the real impact? What will be the real impact of this amendment? And there's one example that I'm thinking of, and I don't know about this case other than just press reports. And I was wondering if anyone here was involved with these cases. But I'm thinking of the example of Jared and Kay Jewelers. There were statements in the press from lawyers. This was not one. There was not one person like Roger Ailes engaging in serial harassment, but it was just so prevalent at the company. And there was a statement in press reports from the lawyers representing the victims of sexual harassment at these two jewelry stores, saying that confidentiality wasn't so much about publicity, but it impacted each victim's ability to collect evidence and discuss the case with coworkers. And so it just made it a harder hill to climb. They weren't seeking publicity per se, but they wanted the ability to ask and talk with other coworkers to gain information and show maybe a pattern of what's going on or policy at the workplace. And so I just don't know how widespread situations like that really are. But I see it for that example of Jared and Kay Jewelers. I would say that this amendment is tremendous in that fact pattern.
I think you're right. I think in these NDAs now, they have to have a carve out. At least in New York, it's required to have a carve out for being able to make filings with any agency like the EEOC or human rights. And I think I have the feeling that the plaintiff's bar gets around it, and they are able to share information like through that mechanism of filing an EEOC charge or something like that.
That's a great point.
Oh, I was going to say, I think there's been some great comments in the chat, and one that I wanted to point out was a question about whether or not this would impact employers as they look system-wide at their dispute resolution processes. And so there was a comment in the chat about whether or not this type of legislation would actually increase the creation of ombuds offices. And that might be really interesting. And ombuds offices are currently very popular in public places of employment, federal governments, state governments, colleges and universities, some large employers, including hospital systems and that type of thing. And I think there's so much value to an ombuds office. They do a very different thing than what mediators do, but they can do mediation. One of the things that I really like about an ombuds office is that, and you'll see it through ombuds reports, and that is they can pick up trends. And ombuds offices can pick up trends internally in a way that other types of processes might not. And so if 10 sexual harassment cases are sent by inside counsel to a private mediator, the number of people who would know that is relatively limited. But if an ombuds says, there were 50 contacts that dealt with sexual harassment or sexual assault, and that is a report that is published to the entirety of the organization through normal annual reporting, that might also have some really positive or potentially positive effects on the workplace. So I didn't want to let that comment kind of just go unnoticed, that there might be an increased role for ombuds and an increased demand to create ombuds offices.
Yeah, that's a great point.
I think employers will definitely have to revisit their entire policy of how they handle dispute resolution. And I'm thinking of the one tiny little sliver of this. I think arbitration agreements have to be revisited. And the statute is really silent. It doesn't mandate how this exemption will be rolled out. And so, in other words, the amendment doesn't discuss what, if anything, the companies must tell their consumers or their workers. And ideally, I think an arbitration clause should now include just an express exemption for harassment and assault claims. But we don't know yet how, whether we're taking an extensive view, a broad view, or middle view. I think that will be interesting in how people get around that with drafting. But I think an arbitration clause should now have an explicit exemption to capture this amendment in some way. Because imagine an arbitration clause simply says broadly, you and I agree to arbitrate everything between us. A consumer or a worker, they incorrectly believe that they must arbitrate everything, especially if they're appearing pro se. And even some lawyers may be in the dark about these amendments. I just did a quick search of Section 2, for example, the FAA, and some citations online won't even include the new addition, except as provided in Chapter 4. So I think some people may just be unaware of this amendment. And this is an extreme argument, but if a company fails to amend its arbitration clauses to include explicit exceptions for harassment or assault, I'm wondering if the company can be viewed as having almost like unclean hands. In other words, how can a company use the FAA to enforce a clause in any setting when the clause is in violation of the FAA because it doesn't recognize this exemption that's required by the FAA? And there's a loosely analogous scenario. It's not exactly on point, but a few years ago, the EEOC went after the Applebee's restaurant chain because their arbitration clauses were drafted very broadly, and there was no exemption or recognition that a worker could file a complaint with the EEOC. And so Applebee's had to go back and amend its arbitration clauses to recognize that workers could still file these complaints with the EEOC, notwithstanding the arbitration agreement. And so if that was viewed as an unfair, deceptive practice, then I would say arbitration clauses, they must be amended today to now explicitly recognize this new exemption, recognize this amendment. So in other words, if there's no express exception provided, I'm wondering, can you argue that the company or the employer is acting in a misleading way or in bad faith? So I think that I think that companies do have to revisit not just their entire handling of dispute resolution. I think this amendment will cause that revisiting, but also how are they going to roll out this amendment in terms of their individual arbitration agreements?
Yeah, I mean, there's definitely leverage for change, right? Because they want to avoid the litigation about the law, right? And so it does make a lot of sense to sort of come up with new plans and to think about dispute resolution. We have a question in the chat as well. I see, so Jim asked also about online options and online ombuds. Would any of you like to speak to or address the question? It's a great question.
It sounds great, but I'm not familiar.
So the idea would be that if you could use an online ombuds and have an online mediation with sexual harassment, for example, could online processes be ombuds, mediation, arbitration work in the area of sexual harassment? In other words, so online, using Zoom or a different mechanism, perhaps creating some safety for the plaintiff in this case, that they're not in the same room, that might actually feel more safe, right, with an online aspect. So I wondered if anybody had any thoughts on that. And go ahead.
I can address that, and then we can take the question from Zaman. But and so I mediate quite frequently in the area of family law, and the area of family law is another one of these areas where we deal with sensitive issues involving allegations of abuse. Whether that be against, versus intimate partners, abuse involving children, other sticky topics, including arrest records, dependency issues, and all of these things. And I routinely mediate these cases online. I've mediated, I estimate that I mediated about 50 cases, mostly family cases, online last year. I usually have about one a week, and there are some real advantages, if we just kind of go by analogy of using these online processes. Safety is certainly one of those, in terms of not having people in the same room together, not having people in this building together, not have people going out to the same parking lot together. All of those are safety pieces that are really nice and that we can take advantage of. And then I do like to tell my parties, anything that we could have done in person, we can do here. And I mediate entirely synchronously, so I cannot really attest to some of the more sophisticated systems that some people on this call have created. But these ways to be able to ensure, and of course there's risks, particularly on the confidentiality side. We need to be careful about reporting and those types of things. But I do think that there are some advantages for online processes, particularly when we are dealing with sensitive topics and dealing with in areas where safety and violence might be a consideration.
And please, I see a hand. Go right ahead.
Thank you, Amy. First of all, I'd like to thank everybody for hosting this program. For me, it's a very big learning experience, particularly in the field of, how sexual offenses relate to arbitration. I'm currently a dispute resolution fellow at the American Bar Association's section for dispute resolution, and this is wholly new to me. I have a British law degree, and we arbitrate commercial disputes. We never engage in, arbitration for sexual misconduct and stuff like that. So it's something new for me. As regarding to what is being discussed today, my question was, for everybody in the panel here today, that what do you think is the impact that the new legislation would have on court annex mediation and arbitration? That's basically my question. I don't have any follow-ups for that. That's just it. Thank you.
Who would like to take it? Anyone? Dana or Abgail, do you have a thought?
I've never considered this issue. I'm wondering, is there going to be an impact? I think that all these processes are post-dispute and voluntary. I think they may be fully considered, like a court-annexed mediation program or arbitration program. I think because they're voluntary nature, I think they're fully consistent with the amendments. I haven't given that. I had to give it some more thought, but for my gut reaction is, I'm hoping there won't be interference.
Yeah, I don't think my feeling is that there would not be an impact if there are court annexed post-dispute agreements, because this law, as with most, do not have an impact on post-dispute agreements to arbitrate. And so if somebody does fully consent and go to that arbitration process with full information, then it probably would go ahead to arbitration. And there may be employees that choose to go that route.
Well, and I think that, and I think he pronounces his name Zaman. I'm not 100%. Okay, good. Am I close enough?
Yeah, you're right. On point.
Thank you. You asked a very interesting question, particularly about mandatory mediation, because so what the amendments to the FAA say is no pre-dispute arbitration agreements, and it is silent on the issue of mediation. And whether we're talking about kind of a settlement week or a mediation that is done through a mediation program, most of the time we would see that there might still be a referral to a process. Now, and as Jim noted in the comments, of course, there would need to be a court case in order for there to be a referral. But to the extent that Congress, and maybe Imre, who studied the legislative history of this act, might have some better idea than I do from the legislative history about to what extent is Congress thinking that these cases would actually settle in court versus be settled, with the 90+% of other cases that are settled settled through mediation, settled through negotiation. To the extent that this was touted as something that would bring increased transparency, increased access to the court, there might be an argument that just the court's regular processes these days of sending cases to mediation over objection of parties, which happens all the time, there might be an interesting policy question of whether that is still fulfilling the intent of the act.
Your question reminded me of something else too. You mentioned that you really hadn't seen arbitration of sexual harassment claims. And something I'd like to stress, and Justice Kagan mentioned this in a speech recently, that we're all textualists now. And if we really applied that approach to the FAA, we wouldn't even need this amendment. There's some language in Section 2 that, arbitration agreements are binding for disputes that arise out of a contract. And my right to be free from assault and from harassment should have nothing to do with the contract. And so I think that, but since the 1980s, the US Supreme Court has interpreted this statute to cover virtually everything. And I think the court has really deflected any close scrutiny of the actual language of the FAA and focusing instead on the substantive law. Like, is there anything in Title VII that prohibits arbitration? But if you put aside Title VII, if you look at the FAA, it was just never designed. It was really just for shipping disputes, contractual disputes. And I really see such a public dimension for sexual harassment claims. And that's why I'm in very big favor in terms of this amendment. But there was really no need for the amendment had we been interpreting the FAA correctly all along.
Yeah, it's funny. I was at a lunchtime program and spoke exactly about the same issue, but then, we are where we are, and we've talked a lot, we've heard a lot of really great comments. Thank you, everyone. Thinking about online options and how technology could play in, talking about ombuds and thinking about how we might craft dispute resolution programs. Another question that has come up is how arbitral institutions will deal with these. So if somebody goes ahead and files their claim in arbitration, obviously you could have waiver issues, but you wonder if they will also be proactive. I know, George Friedman already has said that, he thinks they will. I wonder, Imre, please.
Yeah, I think that arbitration institutions, and if you're working as an arbitrator on your own, I think you're likely to face these same problems that courts will face interpreting this scope. So I think the more likely place where we're going to see litigation, where we're going to see debates about the scope of the amendment will be in court. Courts will definitely have to sort out if they take a strict view, a narrow view, or a middle of the road approach. But I think arbitrators will as well. And so arbitration associations have to as well. I'm thinking of this hypothetical. Imagine a worker files a harassment claim in court, thinking there's a narrow view, so the harassment claim can't be arbitrated. And simultaneously, the worker files all other related claims before an arbitration institution. And we just don't know, will a jurisdiction adopt a narrow view or a broad view? But I'm wondering, will an arbitrator or the arbitration association have a duty to speak up and say, wait a second, I'm not so sure about the scope of the amendment. I'm not sure whether the narrow view, which you're assuming, actually controls. Under a broad view or middle view, maybe none of these claims are arbitrable. And so I'm wondering if an arbitration society or institution or an arbitrator would have a duty to speak up and say, stop, I don't think these claims are arbitrable under certain views of the amendment. And this reminds me of the class arbitration debate. I don't know if you remember the clause construction awards that go on with the AAA. I think that the AAA policy is that once the clause is interpreted one way or the other, there's a pause to let the parties go to court. And some courts will say that this is a partial award, it's unreviewable at this point, and other courts will accept a review. And so I'm wondering if something similar could apply here. But the problem is the statute says that courts shall decide the scope and the applicability. And so normally the arbitrator would have the power, and I think arbitrators will be faced with these questions as to the scope of the amendment. But we've got the language from the statute saying no, with no exceptions, that courts will determine this arbitrability problem. So I think that arbitration societies definitely will have to grapple with certain fact patterns where this issue can arise.
You know, just yesterday, I'm on AAA's employment panel, and just yesterday we received an email from the person in charge of AAA's employment roster saying there's this new law. Even if there's a delegation clause within the arbitration agreement, arbitrators cannot decide this issue, and we can't handle these claims. Now, having said that, what has occurred previous to this amendment is when there's a question of arbitrability or whether a claim is properly before the arbitrator, the arbitral institution will say, arbitrator, it's up to you to decide. So they're not going to make real merits decisions about what claims fall within this. They're going to leave it up to the arbitrator. So I think you're exactly right, Imre. We're going to be faced with this. Do we have jurisdiction? It's people know that under the FAA, there are very narrow grounds for vacating an award, and one of the grounds, and it's in fact the most frequently used grounds, is that the arbitrator exceeded his or her authority. And I can see if we don't have jurisdiction over these claims, I can see somebody saying, no, I do have jurisdiction. This really isn't a sexual harassment claim. It's some other kind of claim, going ahead. And then there's a ground that you exceeded your authority. So there's lots of thorny legal questions that come up here.
Mm-hmm. Yeah. Well, and also I know when we were in the pre-call and we were discussing this last week, we also talked about state law and the interaction with state law. Maybe you want to speak a little bit to that as well.
Yes.
Are you referring to me or to Imre? Go ahead, Imre.
Either.
Go ahead.
It's so this is not crystal clear, and I haven't fully developed these arguments, but I do see some problem areas and how this would interact with state law and state sovereignty. And I fully support the goals of the amendment. I love the amendment. Actually, I wish it was broader. But I must admit, I do see constitutional problems. And if you think about it, assault and harassment claims under the statute, under this amendment, they're defined to include state law claims for harassment, state law claims for assault. And so think about what Congress is trying to do here. Congress is telling state courts how state courts must handle state law claims. And these are claims that are traditionally within the sovereign police power of a state. And so I do see some federalism concerns, like why can Congress control how state courts enforce state created rights? And I think with a couple of the other questions or comments involved a lot of creativity with arbitration or dispute resolution, like let's have an ombudsperson, or someone from South Africa mentioned that they have sexual harassment claims that are arbitrated, but it's done publicly. And I love that creativity that can exist with dispute resolution. I think it should be promoted. And in some ways, this law is like, if you look at it from a federalism perspective, it is crushing creativity or experimentation. I think that states should be allowed to say how a state law will be enforced. For example, we may come up with some type of hybrid arbitration system that involves some public features. Maybe the arbitrator will be approved by the state. But now all that is pretty much gone because states must allow access to their courts for these types of claims. And so I do question the power of Congress to regulate dispute resolution. I do question the power of Congress to regulate state court procedures. And this is, I think, a little bit related to my prior comment that this is not really commercial in nature. In 2000, there's a US Supreme Court case called US v. Morrison. And the Supreme Court held
I think
gender-based assault, that it was viewed as unconstitutional. And I think my internet just went out briefly, but there's an older Supreme Court case, I don't know if this was cut out, but the Supreme Court held that assault claim, that Congress could not create an assault, a right to sue for assault, because it's not viewed as economic activity. And so assault, it's horrible and should be categorized maybe under tort law, but it's not really commercial in nature. And so I question whether under the Commerce Clause powers, can Congress really regulate how states will handle state law claims? And so I don't know who will raise these arguments. I think it's more theoretical, possibly the Chamber of Commerce, but from the optics perspective, to argue against this statute, I think will be a hard hill to climb. But I do question whether, as at least applied to states and state law claims, is this amendment actually constitutional?
Interesting.
Yeah.
I hadn't thought about that. Yeah, another point.
Well, I'm trepidatious about, seeing it differently. I am not a scholar, but I almost think, Imre, you're making it sound more complicated than maybe it is. We have to remember this is an amendment to Section 2. So it's really just talking about whether the FAA is going to apply. So I don't really see that as impinging on any state law. Also, talks about defining the tort as under state law, but that could be still a case in federal court.
Yeah.
They're not necessarily talking about state court cases. That part I don't know.
Well, and I want to sort of talk a little bit more about creativity quick, because I want us to really sort of hone in now on kind of the question asked at the top of the hour about what now, right? And we've talked about sort of mediation, ombuds. I also think just essentially my job as a lawyer, right? So I'm going back to the days, I would do risk assessments and I would provide decision tree analysis and try to help my client work through problem solving. And I feel like this is a moment where it should go into that risk assessment, because as we're talking, I'm just kind of building sort of a framework for analysis in my head, a decision tree analysis. And I wonder, especially with Dana and Abgail and with your clients, because you would work out sort of these, because they need to understand the risk of litigation about arbitration or what they're giving up if you go to court versus trying out mediation. Another comment that was made earlier, which I really think is apropos, is I can see more things going to mediation simply because of the risk of litigation and not wanting to pay those costs, because money matters, right? And litigation is expensive. I wonder if you have any sort of thoughts about that, or if anybody on the panel has already, or anybody in the audience has already had this conversation with a client, for example.
Before we do that, I'd like to take the counterpoint. And so, Amy, I love what you just said. I love everything about what you just said. And I love the lawyers who are out there who are really looking at the creative type and those risk analyses and those sorts of things. But I always go back to the fact that what we are doing is we're battling psychology. And so this is where, this is kind of that age-old debate I think our field has had regarding voluntariness, regarding pre-dispute agreements, whether they be pre-dispute arbitration agreements, pre-dispute mediation agreements, and the question of what happens and what changes in the relationship once a dispute arises. And that was always kind of, and we can, debate all day. I'm not here to debate regarding kind of bargaining power and who the FAA was intended to apply to. But at its theoretical level, a pre-dispute arbitration or a pre-dispute mediation agreement was intended so that both parties with cool heads could be creative and open and think about what does the future look like if it doesn't look as good as it does right now. And unfortunately, once a dispute arises, our psychology tells us to be distrustful of the other person. And this is where I think all of these good intentions that we as neutrals have doesn't necessarily meet the clients where they are, because when there is a dispute, the question is what is the status quo? And so I'd actually be interested in, and I don't mean to put Dana on the spot, but we were talking a little bit about this in our pre-call the other day, and that's the question of post-dispute arbitration agreements and how frequently we think that this might happen. I have some real concerns that parties will not be interested, because any type of change to the status quo, whether that be litigation or arbitration or mediation, when you have parties in dispute who are, our brains are taking these different shortcuts, I just wonder about how frequently they would. And I think we see this in the mediation context. I think we're seeing more and more post-dispute mediation, but not the groundswell of post-dispute mediation that we thought we would see in the 80s and 90s. And instead, most cases are mediated mandatorily, and people still like it, but it's this question of how do we jump the hoop, or how do we get into that process? And so, Dana, I know you had some thoughts on kind of post-dispute arbitration agreements, and I'd like to hear more about that.
I think it's going to be the exceptional plaintiff who's going to agree to go to arbitration on a sexual harassment claim, simply because if they're represented by lawyers, we go back to what Abgail said, there's just more leverage if you're in court or you're potentially in court. There will be some who will say, no, I really prefer to be in arbitration, but I think it's going to be the exception. I don't think we're going to see these claims very often in arbitration. Abgail, do you disagree?
I don't. I really don't. And I think it's too bad.
Right. And it's, yeah, I agree, because there are those benefits, notably some of the benefits that we have been talking about earlier regarding that public mark, right? What happens if you do an internet search and see that employee has filed a sexual harassment dispute? And so we can talk about those benefits, and whether we're talking about, whether it's client psychology, lawyer psychology, leverage, money, all of those things.
I mean, do we blame the lawyers? Because maybe it's the lawyers that are really going to be the problem for post-dispute, because they'll think, oh, we have more leverage and get a higher settlement if we go to court. But won't litigation about arbitration sort of impinge on that leverage?
Well, that's like public works project for lawyers, right? More motion practice. But let's not criticize lawyers. If they want to get a higher settlement for their client, that's a good thing. That's being a zealous advocate.
One unintended consequence of all of this may be to discourage plaintiffs from bringing claims, because they know that they're going to be in the court of public opinion. So I don't know that that's going to happen, but I think it's worrisome if that happens.
Mm-hmm. Well, and also that brings us back to another thing we talked about, and we talked about a little bit today, but we talked more about in the pre-call, but about PAGA claims and what might happen there. I don't know if anybody wants to speak to that issue as well, because that can, of course, cast public light on some of these issues. I know, I believe, Imre, you've talked about that before on the listserv. I don't know if anybody else had any thoughts on those claims, especially coming out of California. I wondered if you had any thoughts, Abgail.
On PAGA, I have to defer to Dana. I do have a thought about what Dana just said. Could I just
Oh, yes, please.
Before we get to PAGA.
Please do.
I think, Dana made a great point, but I wonder if it'll be the resurrection of the demand letter, which, could really be the way to get the attention of the company before filing either way. And like I said before, maybe both sides will stop and think, do we really want to go down this road? PAGA.
So for non-Californians, PAGA is a Private Attorney General Act in California, which basically says that a private plaintiff can stand in the shoes of the state to bring a complaint about an unfair employment practice. I mean, that's a gross oversimplification. But there was a California Supreme Court case a number of years ago, I think 2013, Iskanian, I've always called it Iskanian, that basically said that employers cannot, that the PAGA claims are unwaivable, if you will. So before that time, there had been a question about whether PAGA claims were part of the class action waiver. So every employment agreement that I know contains a class action waiver, and do PAGA claims fall under that class action waiver? The California Supreme Court said, no, it's not a class action. You're really suing on behalf of the state, so it's a state action. And courts have split virtually every California state court that has ruled on this issue subsequent to Iskanian has said these claims are not arbitrable. So what happens as a practical matter, and I see this over and over again, is that there'll be a motion to compel the entire claim. The court will hold on to the PAGA claim, stay the PAGA claim. The rest of it will be sent to arbitration, and then there'll be arbitration of the underlying claims. We'll go back to the court, and who knows what happens with the PAGA claim after I resolve or I render an award. Some federal courts have said, and the Ninth Circuit have said, no, PAGA claims are fully arbitrable because an employee can agree on behalf of the state to arbitrate a claim. And in fact, that very issue is in front of the Supreme Court, just got argued last week. And Imre, and the only reason that we discussed it is it's relevant to the question of, does a court, when they consider the arbitrability of claims of causes of action, how do they resolve that? And PAGA gives you one way that the court will resolve it. We'll hold on to it, we'll stay this claim, the rest of it will be arbitrated, and then you'll come back to court and we'll resolve the PAGA claim.
The mess I think that we're seeing, or that we have seen with PAGA, I think it's going to replicate itself with this new amendment. Like, will the court hold on to certain claims or send everything to arbitration? Regarding PAGA, it's PAGA debates with arbitration going back to Iskanian, it's been around for almost a decade, and there have been cert petitions filed, like multiple cert petitions, almost filed every year, about how PAGA interacts with the Federal Arbitration Act. And it wasn't until this term that the Supreme Court accepted cert in this Viking Rivers case. And what I'm wondering is whether this statute or this new amendment, and there are also other bills pending right now to broadly ban arbitration in the consumer context, the employment context, is what's going on in Congress. Did it impact the court selection of these of arbitration cases this term, including PAGA? There are 4 other arbitration cases being heard, and this is unprecedented in the Supreme Court. They'll take maybe 1 or 2 cases a year. Sometimes there's a trilogy of 3 cases, but not 5 separate cases. And so I'm wondering if the broader debate that we're seeing in Congress and in public eye, like, to what extent should we use arbitration for our disputes? I think it's spilling over to the court. Maybe the court's thinking, well, if we want to continue having a broad FAA, we've got to clean up the mess that already exists. And I think there's a strong interest, of course, in judges promoting arbitration. It's just one less case to hear on the docket. And so I'm wondering if, say, the PAGA dispute is somehow indirectly related to what we're seeing in Congress with this amendment. But in the oral argument during Viking River, the justices, it's so hard to predict. They were all over the place in how they were describing PAGA. Some justices viewed it really as a claim by the state. Other justices viewed it as a procedural right. Other justices viewed it as more substantive. And if it's a substantive right, we're going to have a clash, really a stronger clash with arbitration. So arbitration should not be used to undermine a substantive right. But if it's viewed as procedural, this is a mere joinder rule. I think the FAA should override PAGA. But I'm curious to see when that decision comes out. I'm expecting it'll come out later on towards the end of the term. It's probably just I think it's an important case in the employment context. Whatever happens here in this PAGA case could set a blueprint for other states to adopt similar PAGA mechanisms. And some other states, like I think Maine, New York, they've considered PAGA legislation recently.
So in the chat, we have some really good points I just wanted to raise. So Noah says, isn't it the case that it's easier for defendants in court to get a summary judgment dismissal before trial as opposed to summary disposition and arbitration? And maybe plaintiff's counsel should be more open to arbitration than the usual knee-jerk preference for litigation, particularly when considering the privacy, confidentiality benefits of arbitration. This point on summary dismissal is well taken. I wondered if anyone had any thoughts on that issue.
I think that the comparative outcomes between arbitration and litigation are very hard to parse. I think the data is very tricky. It's not apples to apples for many reasons. And so people point to different things, more failure rate in court, but lower awards from the arbitrator. It's very hard to say. So I think the lawyers fall back on anecdotal evidence from their own experience and their colleagues. And, for now, they seem to be, at least before they had the choice, they seemed to always say, well, we would have, we'd be much better off in court, and this is very unfair. We'll see.
That's the plaintiff's bar.
Yeah.
I have to say, with respect to the question of summary disposition, I don't know that it's easier to get a summary judgment in court. That's the common, that's the received wisdom, but it really depends on the arbitrator. You know that courts uphold summary judgment that arbitrators render as long as they consider the evidence. And at least AAA has a procedure whereby the arbitrators do a two-step process where they determine whether a summary judgment motion has a chance of succeeding, and if it has a chance of succeeding, they'll go ahead with it. So I think it depends on the arbitrator and their practice. I know many arbitrators will not consider summary judgment motions. Many arbitrators will. I will as an arbitrator, because I think that it helps the efficiency of the process. If there's a case that should not go to the merits, it shouldn't go to the merits. So it really depends. And I don't know that anybody's gathered the statistics on how many cases are resolved through summary adjudication in the employment context and arbitration, but I would hazard to guess that it's more than people think.
I was gonna maybe say the opposite of what Dana said. I would, and maybe everyone just has their different. And I agree with Abgail that you can find data that supports your view, and I have run across data that shows that the discrimination claims, I don't know about sexual assault, but I think the harassment and discrimination claims have relatively low, relatively low success rates at trial. And there's lots of things that can go into that, including settling meritorious cases and not settling non-meritorious cases. And I do think that that if you are doing that risk analysis and the decision tree analysis that Amy was talking about earlier, I think I would hope I'd hope that lawyers are being honest about on both sides, honest about likelihood of success at these various places, including Rule 12, Rule 56. But one of the things that we as mediators know, and I know there's many mediators on this case, if you ask any plaintiff's attorney, their likelihood of success on the merits, and any defense attorney, their percentage likelihood of success on the merits, we always come up with a number over 100. And so somebody is always wrong, and it can be difficult for the attorneys and the clients and the mediator to have a good sense of where those judgment errors are. But go ahead, Imre.
If I could share something about just a historical perspective on this problem. I think there's just been a creeping nature of having more summary dismissal procedures in arbitration than before. When I look at the FAA and when it was enacted, there was no such thing as summary judgment in the 1920s. If I look at early arbitration practice, if I look at the very beginnings of the AAA, you were having a hearing. There was no summary dismissals. And I'm noticing a creep more. This is more anecdotal and also just comparing it to the 1920s. But today, I think that there's greater acceptance of dispositive motions, even when it's not explicit in the rules. I'm finding parties still making dispositive motions before me. And what I was thinking not in terms of summary judgment, but in terms of 12b-6 and Twombly in federal court, with the heightened plausibility standards. I was thinking, wouldn't an employer rather be in court to take advantage of summary judgment and of plausibility pleading, at least with respect to federal court? And I've noticed that some arbitration agreements are beginning to incorporate the federal Twombly standard, plausibility standard, and arbitration. And so I'm seeing more and more of a creep of increasing use of dispositive motions in arbitration, at least compared historically. And I don't know how that, Amy mentioned this decision tree. Would I rather arbitrate or mediate? And I'm paralyzed just thinking about it, because every arbitration clause can be so radically different. It's so hard to make that determination.
So Brian asks, and I mentioned this earlier, I know there have been movements in this direction. Brian asks, I wonder if there has been any uniform effort from ADR professional associations to lobby Congress to fix the loopholes, ambiguities in the new law. Not sure I've seen a uniform position from the DR community. Great point. The one thing I did learn in talking with George Friedman is that FINRA is moving in the direction of having some sort of a statement. We heard from Dana, I think you said you received an email from AAA about not being able to decide certain things. Does anybody have any further thoughts about these professional associations and where they might be going with it? Also ABA and the American Bar Association, if they might take a stance.
So what the ABA has done in recent years is been to, through its policy kind of making arm with its resolutions, and it has supported in the most kind of on point ABA resolution is the resolution to prohibit essentially law firms to include arbitration agreements, and it might even be just limited to sexual harassment claims and sexual assault claims. And so the ABA has taken a statement that would support the new law. The question I think that Brian's asking is you know, is there anything to kind of fix these ambiguities or questions that we have? And I think it's too early, but I am glad to hear that some of the provider organizations are giving guidance. And we saw AAA, of course, do that very publicly a number of times in the class action arena. And so I'm not surprised to hear that AAA is taking similar measures here. And I guess I'm just not aware at this time of the provider organizations and the professional associations talking about approaching Congress through their lobbyists to address some of the questions that we've had today.
Yeah, I don't know. I will tell you this though, in speaking with someone who is counsel in Congress, and just, of course, there are other bills that, you know, we have the FAIR Act, and there's other bills that have been, you know, are on the table. They're probably too broad to actually pass, but I do think there are various lawyers up on the Hill who are discussing sort of broader language and broader laws. I don't know how that really handles the loopholes. It kind of, you know, obviously changes the game or creates new loopholes, right? Or new ambiguities. But it will be interesting to see if any of those laws do actually come to fruition. I don't know if anybody, Imre, yes, you have your hand.
You know, I love this idea of just the dispute resolution community coming together with various organizations. I saw that movement when the FAA was passed. And I think I've seen glimpses of this, like with the due process protocols in the 90s. And I'm thinking we need that again. Like, and it's not just for this amendment. I'm thinking we should address mass claims and how they're being handled, how they're being filed, how they're being financed, and filing fees. I wish the due process protocols were adopted. And so I love Brian's question. I think that there's a broader role for all the different and the prominent organizations to come together again, like they did with the due process protocols, but to address so many issues. Because I see such a, traditionally, this field, I think, respects party autonomy tremendously. And I don't know, if we don't take action, we're going to see, I think, increasing regulation, perhaps, of just the whole field. There's that risk that can happen. And so I think it's very powerful to suggest that the different organizations should get together and perhaps suggest a solution first. And not just for this issue, but multiple arbitration issues that I see.
Yeah, I would say I agree with Kristen. It's early, you know, it's early for these things to happen, but it's also, of course, difficult to get resolutions passed. You know, people have very different views within the organization, so it's hard to sort of have a blanket opinion that comes out of the ABA, for example. Any questions from the audience? I want to be sure that we allow, I only have 5 minutes here. So does anybody have any questions? Feel free to unmute yourself and jump right in. All right, well, I will give you back the rest of your afternoon. Thank you, everyone. Thank you so much for coming. Thank you to the panelists. Thank you for providing insights and helping us sort of wrestle with this mess that it is. Not that we have a clear answer on anything, but I will say this has been a great sort of discussion, fleshing out the issues, and I just really appreciate everyone taking the time today. So thank you.
Thank you.
Thank you, everybody.
Nicely done.
Thank you.